Hi, everyone, and thank you very much for tuning in. My name is Natasha Danson, and I am a lawyer at the law firm Steinica Macura LeBlanc, which is a law firm in Toronto that specializes in professional regulation. And today I'll be talking about some of the employment and human resources issues that have arisen as a result of COVID-19. And hopefully I'll be talking about those issues as they relate or as they're applicable to the group of attendees who are here today. At the outset, I'd like to thank the Ontario Association for Behavior Analysis for inviting me to speak today, and I'd also like to thank Autism Ontario for hosting this webinar. And as just a housekeeping note, we've reserved some time at the end of this webinar for questions, but please feel free to ask questions throughout the webinar today. What's important for you to know is that this webinar has been pre-recorded, and that means that as you watch this webinar while it streams on May 14th, I'll also be watching alongside you, and I can answer any questions throughout the presentation without being distracted by giving the presentation. So all is to say, please feel free to use the question feature throughout the presentation, and I'll do my best to get to them. The only disclaimer that I'll have to give is that even though I'm a lawyer, I won't be able to give any legal advice, and I may be limited in terms of how granular I can get when it comes to answering specific questions. But again, I'll try my best, and please feel free to ask your questions. I'll also note that the slides from today are going to be available for download in the handout section of this interface. And the webinar will also be available on demand after today. I just want to say that, and this won't be controversial, these are really topsy-turvy times from an employment and human resources perspective. There are a lot of changes that have happened to people's workplaces as a result of COVID-19. There have been a lot of changes in the law. It's often hard to keep up. There's a lot of job loss. Many in the workplace are understandably having a hard time adjusting at the very quickly changing landscape. And from an employment law perspective, a lot of the ideas from employment law come from the courts and come from cases that are rendered by judges. And we haven't yet seen, it's all very soon. We haven't seen the cases that have come out of COVID-19 yet, because those cases haven't yet worked their way through the system. But there's no doubt that there are going to be a bunch of cases, many cases that are going to come out of this. And for the time being, there are many unknowns. In terms of a game plan for today, what I want to review with everyone is some of the legislative landscape that applies in this COVID-19 era. I want to focus on some of the new legislation that's come out, the idea of essential workers and essential workplaces. I'm going to review some of the basics when it comes to the health and safety legislation. I also want to talk about human rights legislation. And I want to talk through with you the idea around making changes to someone's job as a result of the pandemic, because those are the questions that I know are top of mind for many people. So whether you can make those changes, the types of those changes that you can make, how long those changes can be in effect, those sorts of issues. And then briefly, I want to discuss some of the human resources considerations when it comes to keeping workers engaged in the workforce and keeping them happy. Because I'm based in Ontario, my comments are really going to be born out of that context, but many of my comments should be applicable across the country. So I first want to talk about some of the relevant legislative landscape and some of the legislation that's come into force or has changed as a result of COVID-19. There was a lot of activity right after COVID-19 was announced as a pandemic. And one of the earliest changes that was made, at least in Ontario, was to the Employment Standards Act, or the ESA. So the ESA is legislation that applies to provincially regulated employees but not to non-employee workers. So not to folks who are considered to be consultants or service providers who are providing work but are not employees for purposes of the ESA, where they're getting wage deductions, where they get vacation, etc. Under the Employment Standards Act, there are several unpaid job-protected leaves that are set out, meaning that employees are entitled to take certain leaves of absences. A big one is the pregnancy and parental leave, which many people will be familiar with. And where an employee takes one of the legislated leaves, with some exceptions, those employees are entitled to reinstatement, or they're entitled to get their job back at the end of the leave. And in March, the provincial government added a leave related to declared emergencies and infectious disease emergencies, which would include the novel coronavirus. And the leave provisions state that where an employee is unable to work, either because the employer directs the employee not to come into work, where the employee is under medical investigation, supervision, or treatment for COVID-19, the employee is acting according to public health information or direction, or, and this is interesting, I think, or the employee needs to provide care to a person that's in some way related to COVID-19. So a big example is childcare. In those instances, the employee, as long as they're covered by the ESA, and this is duplicated in other minimum standards legislation throughout the country, that employee can take an unpaid leave of absence for an indeterminate amount of time to deal with the issues related to COVID-19. And in Ontario, employers can ask for evidence in support of this leave where the evidence is reasonable in the circumstances, but that employee doesn't have to give that evidence until a reasonable or for a reasonable time. So they can proffer that evidence at a reasonable time, contemplating that it may not be reasonable to require that an employee give evidence right away. And the employer is also prohibited from asking employees to provide a medical note if they take this leave. And the government has indicated that it's going to consider these provisions to apply retroactively. So it's going to consider leaves, or it's going to consider that employees can take leave under this provision as of January 25th of 2020. So that's when roughly the coronavirus first arrived on the scene in the province. Importantly, where employees take this leave, and really any leave under the Employment Standards Act, there can be no reprisal. So that means that employees cannot be punished for taking these leaves. And during the leave, any benefits must be provided. So to the extent the employee is enrolled in an employer-sponsored health plan, that enrollment needs to continue throughout the leave. There have also been some changes to the employment insurance regime. I suspect that many viewers are going to be familiar with these sorts of changes as they've gotten a lot of press. And there's also been a high uptake of these benefits. So the government introduced benefits to those who have stopped working because of COVID-19. The big one is the benefit is the Canadian Emergency Response Benefit, or CERB, that provides temporary income support. It's $500 per week for up to 16 weeks. Again, talk about uptake. The government to date has received more than approximately 11 million applications for the CERB benefit from 7.6 million unique applicants, and it's already paid out nearly $30 billion in benefits. Again, a medical certificate is not required for CERB claims that are made after March 15th. Folks who apply are receiving a $2,000 initial payment and then are getting $1,000 every 2 weeks. And again, the benefit is available to those who have lost their jobs or their work as a result of COVID-19. So if you quit your job, those benefits are not going to be available to people in that situation. The benefit is available to people who are self-employed, so not just for the traditional class of employees. And there are certain eligibility criteria when it comes to an individual's earnings before the period of time when they're making the claim. One thing that I always stress, especially when I'm dealing with employers on the issue of employment insurance and employment insurance benefits, which would include CERB, the CERB benefit, is that the benefit is really between the government and the individual, and the employer, the non-worker, whoever is going to get this benefit. And that means that an employer should be very careful when making representations around someone's eligibility to receive a benefit, because the eligibility criteria can be quite opaque. And again, it's between the individual and the government. So as an employer, if you fit into that box, make sure that, well, it's good to be aware of the benefit and the eligibility criteria generally. You don't want to be making any representations to workers around if they can actually get the benefit. There have also been some changes to the Income Tax Act, which I won't spend too much time talking about, only because I'm not sure how helpful these comments will be to the viewers of today's webinar. One important introduction or change to the Income Tax Act, though, is the introduction of the Canada Emergency Wage Subsidy. This is a wage subsidy of up to 75%. It's intended to enable employers to rehire workers who were previously laid off as a result of COVID-19 to help prevent further job losses, and really is intended to better position employers to resume normal operations following the crisis. In terms of eligibility criteria, the employer must be eligible, and who an eligible employer is defined quite broadly. It includes individuals and registered charities. Another big eligibility criteria is that the employer must have experienced a reduction in revenue. Usually the reduction must be, it's either 15 or 30% deduction or reduction, pardon me, depending on the period for which you're applying for this benefit or the subsidy. And you are comparing the revenue either to the first 2 months of this year, so January, February, or to March of last year as a baseline. This is a benefit that's being widely used, and many employers are taking advantage of this. To date, there have been approximately 125,000 claims made, and $3.36 billion have been paid out. Then separately, there is the 10% temporary wage subsidy. That is a program for employers. It's a 3-month measure that allows eligible employers to reduce the amount of payroll deductions that are required to remitted to the Canada Revenue Agency. As with the emergency wage subsidy, who qualifies as an eligible employer is quite broad. And as the name implies, if the employer is eligible, the subsidy is equal to 10% of the remuneration paid from late March or mid-March to June 19th. It's up to $13.75 for each employee, to a maximum of $25,000 per employer. There's also more recently been an announcement around a boost that's going to be available to low-wage essential workers, with the provincial government in Ontario announcing a $4 per hour increase for frontline workers. And these are workers at long-term care homes, retirement homes, emergency shelters. There are other groups, correctional institutions. And in addition to the increase to the hourly wage, there's also the Ontario government has raised a $250 bonus for those eligible employees who are working 100 hours or or more per month. There's been some criticism that it doesn't cover all, this program doesn't cover all low-wage essential workers, but that's a program that's just being introduced and rolled out, not just in Ontario, but across the country. And the different provinces are left to determine how best to support those low-wage essential workers. All these programs, I would note, are quite robust, and they reflect the impact that this pandemic has had on the employment sphere and the government's equally robust response to it. There's also been a lot of legislative activity around essential business orders. These are orders that have been released by the provincial government, setting out what businesses are deemed to be essential, such that they can continue operating. The idea is that all other businesses will have to be closed. Generally, in the Ontario context, businesses can operate remotely, so online, by telephone, or by mail or delivery. Those businesses or organizations can continue to operate. And then, in addition, there's quite a long list of other businesses or organizations that are deemed to be essential. I just want to focus more on the idea of essential workers and essential businesses. So several organizations or businesses in the healthcare or social services sphere have been deemed essential that likely apply to the viewers today. So organizations and providers that deliver home care services or personal support services to persons with disabilities, that's considered to be an essential service. And I'm speaking in the Ontario context, but I understand that this is duplicated or replicated in other provinces as well. Regulated health professionals, so these are individuals who are regulated under the Regulated Health Professions Act. They're considered to be essential so long as they're providing urgent care. It's limited to urgent care, at least, certainly limited to urgent care when that care is provided in person. Other organizations that are deemed to be essential are those providing healthcare, including hospitals, clinics, long-term care facilities, independent health facilities, mental health and addiction and counseling supports. Not-for-profit organizations that support social services and other necessities of life to economically disadvantaged and other vulnerable individuals. And so it's quite, I would say it's quite a broad or expansive list of organizations providing healthcare services that are considered to be essential. There has been, though, some confusion in Ontario, at least, around whether regulated healthcare workers who provide non-urgent care remotely are able to do so. And that confusion has arisen because the Chief Medical Officer of Health issued a directive in late March 19th, with respect to regulated health professions, which stated that those professionals should cease or reduce the care that they're providing to minimal levels where that care is non-essential. There was an exception made for emergency situations, which they defined as time-sensitive circumstances to avert or avoid negative patient outcomes or situations that would have a direct impact on the safety of patients. But that directive was silent with respect to remote or virtual care that was not an emergency situation. And after that directive came out from the Chief Medical Officer of Health, the provincial government issued their first order closing non-essential businesses and exempting other businesses that were considered to be essential and could continue to operate. And that order included, as an exception, regulated health professionals, but said urgent care only. So there's, again, been some confusion around whether regulated health professions can provide non-urgent care if done remotely. And I would say that that confusion persists. There's less confusion for those providing personal support services or other health services where those providers are not regulated under the Regulated Health Professions Act, given the directive and also the Essential Businesses Order. I want to talk about health and safety in the workplace. This is a big issue, I think, right now for those who are continuing to work, continuing to provide on-the-ground direct services who aren't working remotely. This is going to be a big, just the issue of health and safety is going to factor largely. And then the issue of health and safety is also going to factor quite largely as we all return to work and think about what that looks like and what precautions or measures need to be in place. So as a starting point, employers in Ontario and across the country have an obligation to maintain a healthy and safe workplace for their workers and to take reasonable precautions to ensure that the workplace is safe. And then workers, for their part, have an obligation to conduct themselves in a safe manner and to report any hazards to their employers to, again, promote the health and safety of the workplace. Again, it's sort of a brave new world in terms of what those obligations are going to look like given the pandemic and following the pandemic, where it's expected that the risk of or the threat of COVID-19 is going to continue for some time. There's some sector-specific guidance that's available through the Ontario government's website around how employers can improve the health and safety for their workers specific to COVID-19. And I'll be sure to provide that link so that you've got that available when you're viewing the webinar. There are some basic precautions that I think many of you could guess at when it comes to what employers are going to be doing to protect against the risk of COVID-19. To do some screening, basic screening for the individuals who are coming into the workplace around their exposure to the disease, exposure to people who are infected, any travel, which there hasn't been much travel lately, but screening questions that are going to get at those potential sites of risk, hand sanitizer in the workplace, PPE or personal protective equipment, masks being a big one. I think those are going to become quite commonplace. Introducing measures to be able to work at a 6-foot distance. Those are, I would say, some of the basic precautions that are going to be put in place by both the employer and by workers who are providing care in the workplace. And again, I'll provide the link so that you can see more sector-specific guidance that's been released. I had mentioned that many employers are going to be asking their workers questions to get at the employees or the workers' potential exposure to COVID-19. I would say generally that the privacy rights of employees are likely to be attenuated or reduced in light of the pandemic, where employers, I think we're going to see, are going to be taking more, doing things that seem more prying, asking employees or workers more questions about their personal lives to assess the risk. There's lots of talk around introducing temperature screening in the workplace, for example. There's nothing from a legal perspective, there's nothing offside from that type of questioning, at least in Ontario, where there's no provincial right to privacy in the employment context. That's different in other provinces. So there's nothing preventing employers from asking those sorts of questions of their workers in Ontario. And I would say probably even in other provinces where there is privacy legislation that governs the workplace or the employment context, there is going to be, I think, a reduction in the privacy that workers can expect when it comes to employers reasonably screening and asking questions to protect the health and safety of their workers. But the law aside, from a practical and human resource standpoint, I would say before employers introduce these sorts of measures that feel a bit more or that infringe more on employee privacy, the employers are going to want the buy-in of any worker so that sort of questioning will go over a bit better in the workplace, because I think it is or may be seen as an affront. Certainly, I think it would be viewed differently if we weren't in a pandemic situation. I also want to talk briefly about the idea of work refusals. So workers in Ontario have the ability to refuse work if they feel that that work may be unsafe. The legislation, when it talks about work refusals, really contemplates physical and chemical hazards, which isn't quite applicable when it comes to COVID-19. Like a physical hazard being a paper guillotine or a filing cabinet that could fall over in the workplace, and then a chemical hazard being the release of a noxious chemical. Again, that's not quite applicable when it comes to COVID-19, but I am assuming that the Ministry of Labour will interpret the idea of a workplace hazard with respect to work refusals quite broadly. Where someone refuses to work because they feel unsafe, there's always first an attempt. The legislation contemplates that there's an attempt to resolve that issue between the worker and the employer. And then if that hazard can't be resolved, then the Ministry of Labour has to come in to assess the hazard. However, and this is a big caveat, especially for those in this context today, is that the right to refuse work doesn't apply in many healthcare contexts. And that's because for many healthcare workers, there's considered to be an inherent risk associated with the work. So that risk, the idea being that you can't refuse an inherent risk, because then you wouldn't do the work, and that risk was always part of the work. So the legislation, the Occupational Health and Safety Act in Ontario, states that the right of refusal doesn't apply to a person employed in the operation of a hospital, mental health center, or group home or other facility for people with behavioral or emotional problems. When it comes to the legislative landscape, the last issue that I wanted to raise when it comes to legislation is the human rights legislation. So in Ontario, that's the Human Rights Code. But that there's human rights legislation all throughout the country. And the human rights legislation, it applies in several social areas, including the employment sphere or the service sphere. And it applies in social areas to specific protected grounds. So protected grounds, race, religion, gender, sex, including breastfeeding, maternity leave, disability is a big one, family status is another big one. And I would say that when we're thinking through COVID-19, the big sort of grounds that I anticipate are going to come up are those related to disability, which would include coronavirus, and family status, which is defined in Ontario and throughout the country broadly as the status of being either a child or a parent. So any issues that come up around either child care or elder care. And where a protected ground like race, religion, disability, family status is raised in a protected area, such as the employment sphere or the services sphere, those service providers or employees can seek accommodation based on the protected ground. So the accommodation requests can take several forms. So an employee can say, for example, my kids are off from school. I need time off to deal or to care for my children. So the accommodation that I'm seeking is time off, or maybe it's reduced hours, or maybe more flexibility in hours. Again, what the accommodation looks like is going to be very case specific, but an employee or service provider can ask for this accommodation if the accommodation arises, again, in the protected social area and relates to a protected ground. Importantly, and I think many employers are concerned about this, and it's important to know, where an accommodation is provided to an employee or service worker where that accommodation results in a reduction of hours in some way or some time off, there's no obligation to pay for that reduction of hours. So if someone's working at 80% or 50%, there's no obligation to pay for the other 50% when they're not actually providing the work. And for an employer, the duty to accommodate someone who's asking for accommodation, that duty is not absolute. The duty is bound, or it's limited by the idea of undue hardship. So the line that us lawyers and the courts and human rights tribunals say is that there's a duty to accommodate up to the point of undue hardship. And what undue hardship is, unfortunately, is sort of amorphous. It's a case-by-case assessment. It's not always clear, so it's hard to define. It's going to be, again, fact-specific. But generally, the duty or the threshold of undue hardship is quite high. Before an employer can say no to an accommodation request, they have to go through a process of considering whether undue hardship is met, and undue hardship needs to involve more than a mere inconvenience or added cost. It needs to be more than a hassle, because most accommodation requests are going to involve some quote unquote hassle to the employer. And generally, employers do have a duty to consider any accommodation request very carefully, work with the employee or service provider to figure out what the accommodation is, what it can look like, and be quite flexible. I often say, at least in a business context, that if the employer is, unless it would involve the employer going out of business, which maybe is quite, is a bit extreme, the human rights tribunals and the case law in this area really does demand a lot of employers when it comes to rejecting accommodation requests. Then again, the courts also say clearly that accommodation is a two-way street, meaning that an employer doesn't have to provide perfect accommodation or the exact accommodation that's been requested, but they do have to generally accommodate their employees or service providers, unless, again, they reach that standard of undue hardship, which, again, is quite high. We're now moving away from the legislation, and I wanted to address a question that I think is coming up for many organizations. Certainly, we're getting a lot of questions around job changes and whether an employer can make changes to someone's job or to the services that they provide as a result of COVID-19. And this makes a lot of sense, because where an employer is seeing a loss of income or revenue, they may be concerned around their ability to continue paying a worker, especially at the level that they were being paid at before. And they may have some questions around, maybe they want to keep the person employed, but change back or scale back their hours or change their duties in some way. Whenever an employer makes or contemplates making a fundamental change to someone's employment, there's always a risk around constructive dismissal. And the first question to consider is, what is a fundamental change? And the case law is pretty clear that a fundamental change is going to be any change that affects more than 10% of someone's employment. So that's pretty easy to measure when we're talking about changing 10% of someone's salary or income, or 10% of someone's hours, because those are numbers. You can measure any deduction or increase. But it's a bit harder harder to measure when the 10% relates to duties, for example, or reporting structure, assessing whether that amounts to 10% or more. But that is sort of the general benchmark, that if you're making changes to someone's employment and it affects more than 10% of their employment, you're in the red zone when it comes to constructive dismissal. That sort of change will be considered fundamental. And if you're making a change that affects between 5% to 10% of someone's employment, you're in the gray zone. That may be considered to be in the constructive dismissal territory. That may be considered to be a fundamental change, but it's not entirely clear. Depends on the nature of the changes. If the change affects only 5% or less of someone's employment, that's not considered to be a fundamental change. The law recognizes that some limited changes are inevitable in the workplace. And whenever there's a fundamental change made, so this 10% or more change, maybe 5 to 10% change, the employee has a right to claim constructive dismissal. And that's where the employee says, employer, you haven't come right out and fired me, but you've changed my job in such a fundamental way that you may as well have fired me, because the job that you're proposing that I have is not the job that I signed up for. And it's not a job that I agree to take. I didn't sign up for this. I don't want it. To claim constructive dismissal, however, the employee would have to resign or quit and then turn around and make a claim for wrongful dismissal or termination, asking for termination pay, severance pay, etc. But the employee cannot stay in the workplace and effectively agree to the change and then turn around and make a claim of constructive dismissal, because the courts say if you stay in the role and accept this change, generally speaking, you're going to be deemed to have consented to the change. So you're going to lose the ability to claim constructive dismissal. I would say that it's such a tricky time because there are so many people who are, I think, experiencing fundamental changes to their jobs. In regular times, non-pandemic times, they would probably or may not agree to those changes. But in these times, they're given the job market and the fact that there are so many job losses and there's a ton of economic uncertainty, they're not willing to resign, to not accept the change, to resign, and then turn around and claim constructive dismissal or termination because they're too nervous around finding another job. So that's what I'm seeing, at least, is that there are many fundamental changes being made to people's employment, but I don't expect that we're going to have as much of an influx as constructive dismissal claims as the courts would otherwise see, given that people are staying in their jobs and they're not willing to risk resigning and then being faced with unemployment given the job market. From an employer perspective, it's important to know that, and this is related, but from an employer perspective, you can protect against any constructive dismissal claim if you provide adequate notice to the employee about the change, which many employers don't have the luxury of doing, just given that these changes have had to come into force quite quickly. You can also protect against a constructive dismissal claim if the employee consents to the change. So if you can get the employee buy-in, that's good from a legal perspective. It's also going to be good from a human resources perspective because you're going to be working with someone who is on board with the sorts of changes that you are proposing. And I mean, I would say that many employers are considering not so much changing someone's job in terms of their duties or their hours, but they're considering having to lay off the employee, so to halt their work, or considering termination. I've been seeing a push that employers, I would say, are engaging in to come up with creative solutions when it comes to keeping people on board or helping them out through termination, which may be inevitable. But before you consider termination, a layoff could be a good option. So that a layoff is contemplated in the employment standards legislation in Ontario and the minimum standards legislation throughout the country. It provides for a temporary job stoppage or stop for a limited amount of time. And during that temporary layoff, you have to continue providing benefits to the employer or to the employee, but you don't have to pay them. That's something I think that's being used with increasing frequency. Even though the employment standards legislation contemplates that sort of layoff, if the employment contract didn't provide for the employer to exercise that right, the employee in regular times or even in these times would have a claim of constructive dismissal. So the employee could say, I don't consent to this temporary layoff. This is a fundamental change. It affects more than 10% of my job. I don't agree to it. Therefore, I quit, and you need to pay me out my termination, my severance entitlements. But I think, again, in these times, many employees are not doing that. They're accepting temporary layoff. I've seen also many employers reducing the work or calling off work for a time, and thereby allowing the employee or the worker to apply for the CERB benefit or employment insurance, and then the employer topping up the difference between what the individual is getting through the employment insurance program and what they would get at their job. So there are some options that you can consider to try to keep your employees engaged, or if you're an employee, to suggest to your workplace as sort of creative ways that you can stay on board or walk away with some form of protection. It really is unprecedented what's going on in terms of job losses, and the ways that employers have had to quickly, and employees have had to quickly adjust to this new reality where there's a substantial drop in revenue, where people have lost their jobs, and that's sort of cascaded into the general, the broader economy. So I would say, if you're an employee or an employer, seek legal advice if you can to figure out what options may be available to you when it comes to making job changes or accepting job changes. I want to talk through human resources considerations, and that's because with any employment issue, there's always the legal answer, which I'm familiar with, and I'm a lawyer, love the legal answer. But then, quite aside from what the law says or the legislation says, there's usually a human resources answer, which is going to be different. It may be overlapping, but could be different. And that relates to how people feel that they're treated in the workplace. Again, quite aside from what the law says. So I just wanted to raise that what I'm seeing, and I think this is being borne out in the reporting around the employment sphere right now, is that employers who are shining at this time tend to be those who are getting the human resources piece right. So some features of those employers are communicating clearly with their employees or with their workers. They're leading by explaining what their expectations are, what the rules are around health and safety, where they're at. Even if what they're communicating is, we don't know where we're at, we need some more time to figure this out, here's what we're considering. We're going to get back to you on X date. Employers are checking in with their employees through Zooms, through phone calls, etc. So they're ensuring that employees are staying engaged and motivated. I think a lot of employers who are shining right now are those who are concerned with their employee mental health, showing a more caring or adopting a more caring approach, encouraging employees to access benefits that may be available to them. Many employers are shining by demonstrating flexibility in terms of hours, the workplace generally. They're adapting, they're responsive to the employee needs. And I think also they're thinking through, many employers have really risen to the occasion by thinking through what opportunities exist in this situation. So clearly, this isn't business as usual, but some employers are asking what can be done well during this time, what can be done at all, where there's room for improvement. They're reevaluating the workplace constantly and thinking through how to support their employees, what can be done well right now, what's working, what's not working, and what do they want to carry forward when this crisis subsides, which will happen and hopefully will happen sooner rather than later. And the hope is that workplaces and employees will be more resilient after this happens. I think certainly we're going to see a lot more remote work post-pandemic. I think that's probably here to stay, but we'll see. I mean, that's really, I know that there's going to be a lot written in the employment sphere unpacking what went right during this pandemic, what went wrong. And I do think that the workplace and certainly the case law for employers and employees in the province is going to be changed by this. And I just want to make sure that everyone has an opportunity to ask questions. If you haven't already, hopefully you've been asking questions throughout the webinar today. If not, please feel free to use the question feature now, and I'll be online and available to try to answer questions for the next little bit. And while I'm doing that, I'll just turn to the next slide, which is just my contact information. Please feel free to contact me if you have any questions about today's webinar. I'll try my best to address those questions offline. The slide does contain my contact information. It also contains my firm's Twitter feed and website, where you can find up-to-date information around changes that affect professional regulation. And otherwise, I just want to thank everyone for tuning in. I hope everyone is healthy and safe. And again, the slides will be posted after the webinar today, as will a recording of the webinar. So thank you again, and you've got my contact information if you want to be in touch.